Hello and welcome to another episode of Legal Wrangle on corporate laws. I'm Kalyan, joined by my co-anchor Pankaj.
Thanks, Kalyan. In our first case, the major question is, do PMLA provisions have an overriding effect on all other existing laws in the matter of money laundering? This case was decided by the Delhi High Court recently.
The genesis of the dispute is the attachment of an imported car by the Enforcement Directorate. The car was subject to hypothecation. When the owner of the car defaulted in paying dues, the bank initiated its measure to secure the asset to recover its dues. The provisional attachment order was confirmed by the adjudicating authority. On appeal, the attachment order was set aside by the tribunal with a direction to return the car to the bank. It was on the ground that the car was not acquired from the proceeds of crimes. The ED successfully contested the order of the tribunal before the High Court.
The appeal was heard on two grounds. The first one was the effect of Section 71 of the PMLA, which is an overriding provision in money laundering case, and the second one was the right of third party in the properties attached under PMLA. Answering the first issue in affirmative, the High Court held that laws such as Recovery of Debts and Bankruptcy Act, SAFEZ, IBC are to be construed in harmony without one being in derogation of the other. Where there are assets tainted with a strong assumption that they were obtained with proceeds of crime relating to any of the scheduled offence under the PMLA, Section 71 provides an overriding effect.
Speaking on the right of third parties, such as financial and secured creditors, over the attached assets, the High Court stated that the burden is on the third party to present evidence for release of attached assets. Though it was accepted that the charge created in favor of the third party cannot be declared as void unless there are materials to show that it was created to defeat the purpose of PMLA. The banks must show with cogent evidence that it has credible stake in the asset which is not illegal and it was not privy to the offence of money laundering. In the absence of any evidence, the ED reserves the right to also attach any alternate tainted asset which has some nexus with the offence of money laundering.
So, the laws must be construed harmoniously, and in the event of repugnancy into the affairs of special laws, the special law always prevails over the existing ones. Now, let's move to our next case where the Supreme Court has entertained an interesting question of Arbitration and Conciliation Act. Section 12 Clause 5 of the Arbitration Act is a disabling provision for the arbitrators. It says that any person who is in relationship with the parties of an arbitration dispute who falls under any of the categories of 7th schedule shall be ineligible to be appointed as an arbitrator. But there is a catch. The second proviso makes the effect of disabling provision a subject of choice for the parties. This interpretation became a debatable issue in this case.
The fact in short was, the chairman of the appellate company appointed a sole arbitrator to preside over the dispute of agreement regarding a turnkey project. Meanwhile, the Supreme Court passed an order in TRF Limited versus Energo Engineering Projects Limited, which made any appointment of arbitrator by an ineligible person void ab initio. Following this judgment, the appellant unsuccessfully applied for withdrawal of arbitrator, which was rejected on the ground that the respondent had not filed any objection in the appointment of arbitrator. A petition to terminate the mandate of arbitrator was rejected by the High Court.
Setting aside the order of the High Court, the division bench of the Apex Court has held that the proviso to Section 12 Clause 5 will apply only if subsequent to the raising of disputes between the parties, they consent to waive the applicability of subsection 5 of Section 12 by an express agreement in writing. Thus, existence of an express agreement in writing is imperative. The agreement must document that parties have given a go-ahead with full knowledge of the fact that the arbitrator has become ineligible to be appointed as an arbitrator. Thus, full faith and confidence is another essential component to continue with the proceedings under an ineligible arbitrator. Since the present case did not involve any express agreement, the mandate of arbitrator was terminated.
In a sense, once the arbitrator becomes de jure unable to perform his or her functions under Section 12(5), there is no question of challenging the appointment of arbitrator in other provisions of the Act under subsection 1 to 4 of the Section 12 and Section 13. The mandate of arbitrator shall be terminated and he or she shall then substituted by another arbitrator under Section 14 subsection 1. Another pertinent point that the Apex Court gleaned over was the fact that a statement of claim may have been filed before the arbitrator will not mean that there was an express agreement evidencing the acknowledgement of both the parties to continue with the ineligible arbitrator.
Thus, without record of waiver in a separate agreement, the tenure of ineligible arbitrator must end. Moving on, our next case indulges into the question of why the circular of RBI containing a uniform direction to all financial creditors in initiating CIRP process was quashed by the Supreme Court.
The issue in this batch of petitions was the maintainability of RBI circular issued on February 12, 2018. By this, the RBI had issued direction to banks and NBFC for initiating the insolvency resolution processes under the IBC. The circular had directed banks to resolve debts over Rs 2,000 crores within 15 days, after which the expiry of 180 days, failing which the corporate debtor would have to be taken to the NCLT for insolvency action. The circular was challenged on the ground that it failed to distinguish between various kinds of stressed assets. Therefore, the constitutional validity of Section 35AA and Section 35AB of the Banking Regulation Act 1949 being the source of circular was challenged.
Declaring the circular ultra-vires, the Apex Court held that RBI exceeded the direction given to it by the central government under Section 35AA. The RBI can only direct banking institutions to move under the IBC if two conditions are fulfilled. One, that there is a proper amortization of central government to do so, and second, that the authorization is in respect of specific defaults as directed. Thus, the Section 35AA itself was not constitutionally invalid. Instead, it prohibited the power of RBI to act in any manner other than the manner set out in it.
Section 35AA was enacted to deal with a particular default of a particular debtor, and that alone were the subject matters of directions. When the central government authorized the RBI to issue directions, it was only in respect of specific default and not a general default. The RBI cannot issue an indiscriminating direction which applies to all debtors generally. There was no intention of expanding the administrative power of the RBI. With this, we conclude this episode of Legal Wrangle. If you want to find all the cases discussed by us with insightful headnotes, you can find them at www.tiolcorplaws.com. Thank you for watching.